Any solicitor here in the employment team will be able to advise you accordingly and give you the best advice possible. So we always encourage people who've been offered a settlement agreement to come to Machin's. My name's Philip Bain. I'm an employment solicitor here at Machin's Solicitors, and today I'm going to talk about settlement agreements and what you need to know. Settlement agreements are designed to bring employment relationships to an end. These are offered where there is a dispute between two parties, i.e. the employee and the employer, and it can happen via a number of circumstances. Usually the main ones are that a disciplinary has been commenced against the employee, or the employee has raised a grievance and the employer has made the decision to offer a settlement agreement as a result of those ongoing proceedings. With settlement agreements, you are signing away your employment law rights, which are in place from the first day of your employment. Therefore, you are required as a matter of law to seek independent legal advice before you sign these off. You can't simply sign it off if you're happy with it. You have to, as a matter of course, go and see a solicitor. When you are offered a settlement agreement, you are under no obligation to accept that settlement agreement. Usually it's been offered at a time where both parties agree to it, but if it's offered out of the blue by an employer to an employee, it doesn't mean you have to sign it. We can discuss your options as to what would happen if you didn't sign it, or what happens if you did, but you're under no obligation at any point to sign the agreement. There's a very long list of claims that you can settle via a settlement agreement, but the main ones are for an unfair dismissal, constructive unfair dismissal, a failure to pay your notice pay, and also discrimination and what have you. In a settlement agreement, there is a confidentiality clause which ensures that you cannot discuss this with everyone you wish to discuss it with. You can discuss it with a certain few people, that being your immediate family, your independent legal advisor, that being the instructed solicitor. You can also discuss it with HMRC if there was a tax issue. If you breach that agreement, there could be a chance that the company don't pay you under the agreement if they get wind of it before. Obviously, if they've already paid you under the agreement and they can catch on that you've discussed it with people, they can look to take action via a litigation process. There's a number of payments that you will receive under a settlement agreement. Usually this comes down to the money you're owed up to date as to when you leave. Most of the time an agreement will also include your payment in lieu of notice, which will be taxed, your holiday pay that will be taxed, and there could also be a bonus that could be taxed. That's all dependent on your employment contract. The extra amount that you are offered, which is often referred to as an ex gratia or a termination payment, will not be taxed unless it's above the £30,000 limit which is currently in place. If you're not paid, Machin's Solicitors can obviously assist you with trying to get that money back. It's very rare that employers don't pay, but we understand that it is always a possibility, but there is always a number of mechanisms in place that we can put in place to ensure that you will get paid. We understand here at Machin's that when you are offered a settlement agreement, it is often a stressful time for you, and we like to make things as easy as possible for you. We can also help with bringing this matter to an end, or actually sometimes even seeking an increase in the offer of money you've been offered. We consider that we are the best firm for this and can be trusted with all of your legal matters moving forward.